Ladies and gentlemen, we are ready to get started back with our program. So if you would find your way back to your seat, that would be much appreciated. So it is my pleasure to welcome this afternoon Julie Warren. Julie's a graduate from Regent School of Law, and she's a former clerk for the United States Senate Judiciary Committee. After she worked at the U.S. Department of Justice and spent a time in private practice as a litigator and also working in the office of the West Virginia Attorney General, she became and is now the director for the states of Tennessee and Kentucky of Right on Crime, which is a national campaign to promote conservative solutions to the American criminal justice policy. Right on Crime seeks to reform the criminal justice system in ways which shrink big government, save money for taxpayers, but yet ensure our public safety. In addition, Julie is the Senior Fellow for Criminal Justice at the Beacon Center of Tennessee, which is located in Nashville. And the Beacon Center is a nonprofit, nonpartisan, I guess some call it a think tank, and the current president of the Beacon Center is one of our own graduates, a 2008 graduate here of Memphis Law. His name is Justin Owen. Julie's research and all of her efforts on reform have already produced great results. There's some wonderful news articles talking about reforms in Kentucky, and currently she has become active in our Tennessee General Assembly. In her presentation, Julie is going to critique what would be known as sort of a traditional lock them up and throw away the key type of criminal justice approach, as holding that approach as being really quite ineffective as a solution for the opioid crisis. So please join me now in welcoming Julie Warren.
Thank you. Thank you, everybody, for having me. I come to the opioid issue from my law enforcement background, but I'm also from Huntington, West Virginia, which a lot of folks know is the epicenter, ground zero, if you will, of the opioid crisis. My dad, who is a pastor, has buried two of my high school friends who have overdosed from opioids. So this issue is very important to me, and it's very personal to me. And I know this morning we addressed what the medical community can do on the demand aspect of the opioid crisis, i.e. the addiction. And we heard from Tom and Joe about what law enforcement is doing to address the supply, i.e. the trafficking. I'm here to talk about what the criminal justice system's role should be in addiction. In the war on drugs, the primary duty of the criminal justice system is to shut down the supply of drugs. However, too often, it is tasked with containing the demand. This is because drug addiction has historically been viewed as by the criminal justice system as an antisocial behavior rather than an epidemical disease. This view has proven faulty in both the treatment of the disease and the promotion of public safety. As the incarceration rate for drug offenses, including possession, has increased, so has the spread of the disease. And as we learned from Tom, ironically, it's Richard Nixon who is widely credited for originating the idea of the war on drug concept, but who also articulated this understanding in a 1971 letter to Congress, wherein he requested that additional funds be directed towards programs to control drug abuse in America. President Nixon's vision of a war on drugs involved a law enforcement strike on drug suppliers while decreasing the demand for the rehabilitation of drug users. Drug users were not the intended enemy. A fact that is highlighted by the president's request for additional funds to meet the cost of rehabilitating drug users and additional funds to increase our law enforcement efforts to further tighten the noose around the necks of drug peddlers and thereby loosen the noose around the necks of drug users. Unfortunately, though, the war on drugs has evolved such that drug users and drug traffickers are often viewed as a distinction without a difference in the eyes of the law. Indeed, one cannot ignore the fact that crime is often a symptom of drug addiction, and many drug addicts engage the criminal justice system due to crimes they commit in order to stave off symptoms of withdrawal. Especially with the onslaught of the opioid epidemic, jails and prisons across the United States are full of drug addicts who are incarcerated alongside drug traffickers and violent criminals and with limited access to effective treatment and rehabilitative services. And that being said, how should the criminal justice system respond, particularly in light of the opioid crisis? The National Center for Substance Abuse at Columbia University stated it best. It starts with acknowledging the fact that addiction is a disease for which evidence-based prevention and treatment programs exist, and that these programs can be administered effectively through the criminal justice system. This means that the criminal justice system must appreciate the balance of sanction and rehabilitation. It must identify and effectively treat offenders with substance abuse disorder in a way that reduces the risk of reoffense. This means the system must consider diversion programs for nonviolent drug offenders as an alternative to incarceration, while more serious offenders are afforded effective treatment services while they're in prison. These reforms are necessary and popular because the presumption in favor of punishment or incarceration has proven to be an exercise in futility in terms of addressing the demand for drugs. The criminal justice system was not designed to preside over public health events like the opioid crisis. And yet for decades, this tough-on-crime approach that favors incarceration is a concept of justice that has been applied universally to the drug trafficker and the drug user alike. So someone whose criminal act is driven by substance abuse disorder is incarcerated in order to punish that behavior. And what we do is we warehouse these folks with too little attention paid to the disease that drove the behavior. This individual will serve time in prison, then be released still suffering from that disease. So while the individual has been severely punished for the behavior, they may reoffend or die of a drug overdose. So to what end does this punishment mean to serve? Despite the ineffectiveness, incarceration remains the treatment of choice for drug addiction. And this draconian concept is derived from a theory that incarceration is an effective deterrent to drug use. And more generally, that keeping drug users incarcerated for as long as possible keeps the public safe. The effect of this theory has seen the widespread expanse of drug abuse, particularly the opioid epidemic, and a burgeoning prison population, coupled with a profoundly negative impact on recidivism rates. In practice, this theory imposes significant costs to the taxpayer with no public safety benefits in return. In fact, a continued study from the National Center on Addiction and Substance Abuse at Columbia, it's called Behind Bars 2, Substance Abuse in America's Prison Population, has indicated that over half, 52.2% of substance-involved inmates have one or more previous incarcerations compared to the 31.2% of inmates who are not substance-involved. And at an average cost of $25,144 per inmate. Hence, the fatal flaw in the theory is a fundamental misunderstanding that drug addiction is primarily a criminal behavior to be punished and not a disease to be treated. What is the result of favoring incarceration over treatment for substance-involved offenders? Well, again, there's the failure to contain the human toll caused by the opioid epidemic. However, there is also the matter of public safety triggered by the recidivism rates amongst substance-involved offenders. The same study I just mentioned observed that the correlation between the country's burgeoning prison population and the increase in substance abuse, concentrating specifically on the failure to offer effective treatment for offenders with substance abuse disorder, and it highlighted a 33% increase in the inmate population from 1996 to 2006, coupled with the population of inmates who were substance involved having increased by 43%. For its part, the National Institute for Justice has acknowledged that incarceration by itself has not been effective in breaking the cycle of drugs and crime. For its part, the President's Commission on the Opioid Crisis report is very reminiscent of President Nixon's call to Congress. The substance of the report was compiled in consultation with a number of stakeholders, and they published an interim report that contained a number of preliminary recommendations to curb opioid addiction. Many of its recommendations focused on expanding access to treatment and an increased education for prescribers, while a few called for increased coordination among law enforcement to address the supply of illicit drugs. But it called for an enhanced In its call for enhanced sentences for fentanyl traffickers, it warned against lawmakers using these policies to incorporate drug users. The rapid increase in the incarceration rate for drug crime, coupled with the continued widespread demand for illicit controlled substance, reflects the overall ineffectiveness of incarceration as a deterrent to illicit drug use. In fact, incarceration generally fails to deter future criminal conduct. Yet, in many criminal justice systems, incarceration remains the default response to nearly all criminal conduct, including possession of drugs and other conduct driven by substance abuse disorder. Because it's based on the assumption that invoking fear of being locked up for an extended period of time will prevent the drug addict from further drug use. The futility of this assumption is not a matter of opinion, but it's actually quantifiable. According to the Bureau of Justice Statistics, in 1980, there were 25,000 offenders in federal and state facilities whose primary offense was a drug offense. This population now stands at 300,000. The United States Sentencing Commission attributes this overall increase in the federal inmate population to the imposition of mandatory minimum sentences, which became favored in the 1980s. For example, an opioid addict who misrepresents information to their doctor or otherwise obtains opioids through misrepresentation, fraud, forgery, deception, or a subterfuge will be subject to a 4-year mandatory minimum sentence in prison without parole. Thus, drug addiction has continued to spread and reach epidemic levels, even though incarceration rates of drug users have skyrocketed, as well as their sentences, especially where mandatory minimums are imposed. And drug offenders fare no better in the state systems. By the end of 2015, there were 206,300 inmates in state corrections facilities whose primary offense was a drug offense. Of these inmates, 46,000 were convicted of drug possession as their primary offense. Drug offenders are also serving longer sentences. From 1999 to 2009, sentences for drug offenses have increased 36% at the state level. Federal sentences increased 153% from 1988 to 2012. And to top it off, the National Center for Addiction and Substance Abuse found that 65%, or 1.5 million of these folks, meet the criteria for alcohol or drug addiction. Studies with a focus on the effect of criminal sanctions on substance abuse, particularly opioid abuse, have also directly undermined the notion that incarceration functions as a deterrent. The Pew Charitable Trust Public Safety Performance Project recently examined whether and what degree high rates of drug imprisonment affect the nature and extent of the nation's drug problems, particularly the opioid crisis. The examination compared publicly available data from law enforcement, corrections, and health agencies. According to the data, they found there is no significant relationship between a state's drug imprisonment rate and its drug problem. For instance, Louisiana and Oklahoma have the first and second highest drug imprisonment rates, respectively, but also respectively rank 13th and 10th in illicit drug use and 23rd and 10th in drug overdose deaths. Thus, neither state have really achieved the success in curbing their drug epidemic through incarceration. Another observation is that Tennessee imprisons drug offenders at a rate more than 3 times the state of New Jersey, but the illicit drug use rate in the two states are virtually the same. While on the other hand, Indiana and Iowa have nearly identical rates of drug imprisonment, but Indiana ranks 27th amongst the states in the rate of illicit drug use and 18th in drug overdose deaths, while Iowa ranks 44th and 47th, respectively. And these state drug imprisonment rates reveal that there's no correlation between illicit drug use with the illicit drug use and the effect of incarceration. And in a hearken to the logic of President Nixon, Pew represents its view that the most effective response to the growth in opioid misuse, this being a combination of law enforcement to curtail trafficking and halt the emergence of new markets, alternative sentencing to divert nonviolent drug offenders from costly imprisonment, treatment to reduce dependency and recidivism, and prevention efforts that can identify individuals at high risk for developing substance abuse disorders. Not only is the tough-on-crime approach to drug addiction ineffective in deterring demand, but it actually undermines public safety. As Tennessee Governor Bill Haslam has recently stated, spending time in jail or prison can increase the risk of future offending rather than decrease it, and this is particularly concerning when you're talking about a nonviolent drug offender. Allocating limited law enforcement resources to nonviolent drug addicts also creates a public safety risk, since those are resources that must be diverted from investigating and prosecuting violent crime or high-level drug traffickers. Laura Nodoff, the district attorney in Midland, Texas, has publicly professed that in her experience, public safety is actually undermined by the diversion of limited resources away from the prosecution of violent crime, particularly crimes against children. She explained that people who are addicted to narcotics enter the criminal justice system due to possession of controlled substance or because they've committed a nonviolent crime like shoplifting, so they can purchase a controlled substance. And District Attorney Nodoff rebuked the idea that the answer to that type of criminal behavior is to incarcerate them. And her contention is that warehousing nonviolent offenders is costly, does not contribute positively to the public safety, and does not necessarily increase the perpetrator's likelihood of taking responsibility for their actions. Her solution was to utilize the resources available through specialty courts, like drug courts. Pew also affirms this notion in pointing to the lack of benefit incarceration is shown in deterring drug use. It contends that with limited public safety budgets, this can amount to a zero-sum proposition. Dollars spent in one area are unavailable for others. And this is currently playing out in the state of Kentucky right now, where corrections facilities are all sitting at capacity and expected to grow an additional 19% over the next 10 years. In fact, the overcrowding issues within the Kentucky Department of Corrections has compelled the state to transfer inmates into private prisons, which is a practice that the state had previously abolished but now is forced to reinstate because it can't control its own capacity, its own inmate population. The private practice, this private prison situation is simply a Band-Aid, and as Governor Bevin has made very clear to lawmakers that if they don't adopt reforms, or otherwise they're going to be facing down the barrel of a consent decree. The jail population in Kentucky is even more dire, and in Bell County, where the opioid crisis is particularly severe, the county jail is at 3 times its capacity. And Bell County also has the second highest drug overdose rate in the state. So it's gotten to the point where they've gotten rid of the cafeteria and any general population parts of the jail to then bunk people in bunks that are literally 4 or 5 people high in order to sustain their own population. Kentucky's overdose rate is 3rd in the nation behind West Virginia and New Hampshire, and has continued to increase year after year as their inmate population has also increased. A number of the reforms directed towards expansion of treatment and further, they want to initiate a number of reforms that will be directed towards expanding treatment and further regulating prescription practices. But what about the Kentucky's criminal justice system? Kentucky has experienced a 32% growth in 5 years. While admissions for Class A and Class C felonies declined, admissions for Class D admissions rose 38%. In Kentucky, simple possession is a felony, and the number of people admitted for simple possession has doubled over the last 5 years. In fact, there's a 102% increase in new commitments for drug possession since 2012. Parole revocations have also increased by 50%, and many of the low-level drug offenders, for example, those who are caught with possession, are housed in county jails without any treatment access. In fact, half of Kentucky's prison inmate population are housed in a county jail where there are and they do not receive any treatment. And in other words, many of the nonviolent offenders who suffer from addiction, because it's the low-level drug offenders that are put in the county jails, are simply being warehoused and never treated. The Kentucky's female inmate population is up 56% since 2012, and it's now the second highest in the country. 85% of the female population are Class D admissions, and which is up 72% since 2012. And they've had an increase of 140% since 2012 of females admitted just for simple possession. So the increase in incarceration of low-level Class D drug crimes like possession has not translated into a public safety benefit. Kentucky's violent crime rate has actually increased, and in fact, the latest uniform crime data from the FBI shows it has increased 4% just from last year. And Kentucky has not been able to divert its already very limited resources to further crack down on the trafficking into the state. And there are currently reforms pending in the Kentucky legislature that would increase diversion and reclassify possession as a misdemeanor. And the head of the Kentucky State Police actually presented to the House Judiciary Committee begging for these reforms and calling to the table anyone who suggested that these reforms were soft on crime. Since his capacity to investigate high-level traffickers and violent crime has been severely compromised by the state's obsession with going after low-level drug possession. Now, could this happen in Tennessee? Well, simple possession is a misdemeanor, so we kind of dodged that bullet, but the state's felony inmate population has increased 12% since 2008, and its female population has increased 58% since 2008. And according to the Department of Corrections, since 2013, the average sentence for a drug offense has increased from 9.7 years to 10.4 years. Also, it projects that the current incarceration rate is on course to create an unmet bed demand of 7,109 people by 2020. And what is more, Tennessee has a violent crime rate that is 39% higher than the national average. A great example of a state that has really addressed this issue of incarcerating nonviolent drug offenders is the state of Texas. Now, a lot of people think Texas and they think of, Walker, Texas Ranger, and they think of how Texas is sort of the leading in capital punishment and things of that nature, but they've actually really have a bifurcated approach in terms of how they look at crime. They see violent crime and they see nonviolent crime. 2007, the state had a severe overcrowding situation such that they were going to have to immediately invest. They were very similar to what Kentucky is, invest $2 billion in building new jails and prisons. And the state just decided it was going to recalibrate its view. And instead it invested $241 million into 15,850 substance abuse treatment beds and mental health beds. So they were, to the extent they could, diverting as many nonviolent drug offenders into a treatment facility. And how has that impacted their criminal justice system? They've closed 8 facilities since 2008, and their violent crime rate has been reduced by 14.5%. So what is the criminal justice system's role? It does have a pivotal role in the resolution of the opioid epidemic, since many of those suffering from drug addiction can divert into other criminal activity. In order to obtain drugs, it is not uncommon for addicts to perpetrate prescription fraud or steal property and money in order to stave off a withdrawal symptom. Some even revert to drug trafficking themselves. It has been reported that amongst substance-involved inmates, those who have committed crime to get money to buy drugs have the highest average number of past arrests. But it serves neither the interests of the rule of law or public safety to discount criminal acts that are triggered by addiction. But nor are these interests served if retribution isn't balanced with rehabilitation. For nonviolent, low-level drug offenders, the ideal sanction is diversion into an evidence-based treatment program where there is increased monitoring and participation is conditioned on their supervision. It's also important that offenders suffering from addiction for whom incarceration is necessary are not simply warehoused away from the public in order to avoid reoffending. And that's because 95% of all inmates will eventually be released back into society, and these offenders must also be afforded the evidence-based treatment programs. There are certain programs and certain policies that I call fundamental that I believe that should be a part of all aspects of every state's criminal justice system. And first is a risk needs assessment. In order to encourage recovery and prevent reoffense, those who find themselves engaged with the criminal justice system as a consequence to their drug addiction must receive a treatment strategy designed for their specific needs. To that end, risk and needs assessments, or RNAs, are a critical tool that help guide and determine a proper strategy for each offender. It allows the court to understand the drivers of the offender's behavior and determine what programs are needed to address the behavior either through a diversion program or during their time of incarceration. Many RNAs are an objective actuary formula, and the benefit to which is the lack of human bias. The Council for State Governments echoes this sentiment, noting that objective risks and needs of assessments have been shown to be more reliable than professional individual judgment. Regardless of methodology, RNAs, while not designed to function as the sole factor in making a decision and should be routinely validated to ensure their accuracy, remain the best available method for ensuring that a research-based data helps inform the decision-making process. Many jurisdictions require RNAs at pre-sentence level, partly in an effort to find eligible candidates for diversion rather than incarceration, but also to ensure that treatment needs are accommodated throughout the individual's engagement within the system. Tennessee requires these assessments to be included in the pre-sentence report. So the court will then have a better understanding of what this individual's needs are, and every year that person will continue to go through an assessment to determine whether or not different strategies need to be taken. But there's a continuum of care for that individual while they're engaged in the system. And there's room to expand the utilization of RNAs to pretrial detention. For example, the jail population could be greatly reduced if courts would utilize RNAs to determine pretrial detention. According to the National Association of Counties, the jail population has increased 20% from 2000 to 2012, with a rising share attributed to the pretrial population. Jail costs have also increased 74% over that same period. In fact, a NACO survey of different jails, of different sheriffs, found that 75% of all jails cite reducing their jail population as their top priority, and at 28% of their detainees released by that only 20% of their detainees released by respondents' jails in 2014 were pretrial detainees. Another fundamental, I believe, is graduated sanctions. And probation and parole are supervisory functions of the criminal justice system, whereby officials monitor an offender's adherence to the conditions of their supervision. But one thing we're finding, and this is true in Tennessee, 40% of the new admissions to the Department of Corrections were just mere technical violations, meaning these individuals failed to show up for a meeting with their probation officer, or they may have tested positive for a drug, but they haven't committed a new crime. But the practice in Tennessee, and this is shown to be true throughout the country, is they're just immediately revoked and put back into prison. What a graduated sanction program will do, they're a swift and certain immediate sanction, but it's an alternative sanction to revoking and returning this individual to prison. So this person may have, increased monitoring. They may have to go to substance abuse. They may have to be drug tested more often, or they may have to meet with their probation officer twice a week instead of once a week. But there's alternatives to just revoking and returning this individual who has not committed a new crime and is no more dangerous back into the to the Department of Corrections. The number one most popular diversion program that we hear about is drug courts. And the NIJ has acknowledged that incarceration by itself hasn't been effective in breaking the cycle, as we know, but they've taken a very favorable view of drug courts. Indeed, drug courts have emerged as a highly effective tool in addressing the substance abuse issues among nonviolent offenders, with north of 3,000 in operation throughout the country. These courts are described as specialty court docket programs that target criminal defendants, offenders, juvenile offenders, and parents with pending child welfare cases. The Department of Justice Office of Justice Programs has acknowledged that treating the underlying issue of addiction can keep these offenders from recycling through the justice system. Drug courts are alternatives to incarceration, and often the incentive for successful completion of the program is dismissal of criminal charges, the vacation or reduction of sentences, or the removal from supervision. The programs are administered by teams consisting of judges, drug treatment specialists, corrections, social workers, prosecutors, and members of the criminal justice bar, or the criminal defense bar. These numerous studies of the drug courts have shown to dramatically decrease recidivism rates. And we're out of time, but recidivism is the number one measurable to determine whether or not your justice system is working. And to the extent you have diversion programs that have shown to reduce your recidivism, they should be explored and they should be invested in, and they are more effective and more cost saving than just incarcerating and warehousing those with drug addiction issues. Thank you.